and then at schedule lay out the roadmap for Nairobi. The state should stop delaying, procrastinating, delegating, and then coming here and later in public domain lambasting the defense team for their own claims of a snail-paced and lackadaisical approach towards the prosecution. We reject it, and it is join us in treating this prosecutorial misconduct is the contempt it deserves. The issues of sickness are red herrings and are diversionary. They have nothing to do with the disclosure. Have the defense, the prosecution failed to disclose because the clients were sick. So they shouldn't take us there. Let us focus on their duty to give us
prosecution and tens of pages, meaning 20, 30, 50 of transcript from audios or videos we are yet to receive copies of. So we wouldn't know whether those, from whom those transcripts are. We wouldn't know the voices in those transcripts. I've had a conversation with Mr. Jatiko. I think he can brief the court or confirm to the court that indeed they are yet to fully disclose the case our clients are facing. And as such, we feel we should not be going into conferencing when our clients have not been given adequate time and facility.
I noticed from the moment that we received the transcribed material and the original gadgets from which these were transcribed from, we have been in the process of having this material transferred to gadgets, various gadgets, which can enable us ably disclose to them. Some of these include flash disks. Today, I believe there are 18 lawyers here, and so we are really trying to make sure we have copies for all of them. And this will be accompanied by the forensic report. I know the prosecution is confident that if given a date by Tuesday next week, we will.
Mr. Jatiko is saying, no, there was no directive to that effect. This must be sorted, my lord, before we proceed. Was there a court order to that effect that there must be full disclosure by 21st January, given, handed down by this honorable court on 30th of December? We insisted that is the position on record, my lord, and they never complied. And why we are justified in our submission, my lord, in our line of contention, my lord, is very clear. And actually, it's logical. There was no way we would come for scheduling on 21st January before full disclosure is done. It is simply a matter of logic that we were supposed to come here for scheduling on 21st January after full disclosure is done.
What we call case conferencing or scheduling for the court to say how when the hearing will start and how long it will take, all those things are pertaining to hearing. We told the court we couldn't go there because we couldn't start with the case conferencing because the prosecution only did a partial disclosure. They've given us statements of 4 witnesses and transcripts from audios and videos that we are yet to see. The Constitution of Uganda is very clear that there should never be trial by ambush. An accused person and their lawyers must have in advance the evidence against them, all witness statements. If there is a transcript, you give the audio first, long before the transcript. How do we know that the transcript is the same as the audio or that it is authentic? We also have a duty in these days of AI to know whether the transcript is actually a real transcript or a fraudulent one. So on that basis, the case has the court has adjourned the case to the 24th of March, to the 12th of March, and the prosecution has been ordered to give us full disclosure on or before the 3rd of March. Now, the prosecution has been claiming, we've seen it and we've seen government officials, including officials from State House, especially during the campaign period, claiming that it is the defense lawyers who are delaying the case. We want Ugandans and the world to know that up to now, the prosecution has not done full disclosure. Under Ugandan law, the case cannot commence without full disclosure. So the delay in starting Dr. Besigye and Obeid Lutale's case is not on the defense, it is on the prosecution. We also worry about Dr. Besigye's health. Anybody can see for himself that he looks frail. He's getting sick so often in prison. We do not know what has changed in that environment, but it's certainly compromising his health. So I was telling the court, I was pointing out to the court that the health of Dr. Besigye is among the things he must consider, because at the end of the day, the court will want to know whether he is in a position to go on with the trial as he is. I think that is all that has gone on today.
Nga bagamba obujulizi buwedde naye n'okutuusa olwaleero obujulizi obwo tebabutuwanga. Twebuuza sookera ddala obujulizi bakweka bwaki? Oba nga balina obutambi nga basobola n'obutwala ne babusaasaanya mu social media ne batandika obugabagaba buli wamu, lwaki ffe balooya tebabutuwa? Nti obutambi obuliko amaloboozi ga Dr. Besigye n'abantu be yali agamba nti simanya bagula emmundu, simanya bamonitalinge wa gy'abeera wa gy'asula, simanya bagule drone baagala kutta mwami Yoweri Kaguta Museveni. Obutambi obwo buliko amaloboozi ago bwe bagamba bwe bataddemu biwandiiko, lwaki tebabutuwa n'okutuusa olwaleero? Kati bagambye nti bajja butuwanga ennaku z'omwezi 3 omwezi ogwokusatu, katubalinde. Naye ekyo kyekiremezza ne hearing ogenda mu maaso nti obutambi baganya okubutuwa. Ate weebuuze nti oba bulijjo babulina, lwaki tebabutuwa? So yembeera eyo gye batutaddemu, naye ffe ekisinga okutunyiga nti we bulamu bwa Dr. Kizza Besigye mumulabye agenda ayongera okunafuwa, yegenda anafuwa, yeyongera okunafuwa, era tuze tusaba beyiro emirungi mingi, kooti neegaana okumuwa beyiro, naye tukyatakula amateeka na buli kimu okulaba nti tufuna orders eziyinza okubanga ziyambako ku mbeera y'obulamu bwe, naddala okulaba nti abasawo bamuwa obujjanjabi obumala, ate nga nekya beyiro tetunnakivaako, okulaba nga ali bweru asobole okubanga yeerwanako ng'ali bweru, ate n'okubanga yejjanjabisa ng'ali bweru wakomera. Sebyo byonna tukyabiremeddeko mu mbeera yonna. Mwebale.